Good evening, good morning, good afternoon. Wherever you are on this globe, I welcome you to this lecture. This is lecture number 9 that is going to cover the International Criminal Tribunal for the former Yugoslavia. My name is Professor Dr. Milton. I hold a PhD in International Criminal Law, and I welcome you to this lecture. We are aware that the pandemic has affected virtually every sphere of life, and we can only hope wherever you are surviving, and thank you for joining us for this critical lecture. As usual, I usually have to take a retrospective glance at what was covered in the previous session, and you'll recall that in lecture number 8, we dealt with the twin criminal tribunal, which is namely the International Criminal Tribunal for Rwanda. We ought to have started with the International Criminal Tribunal for the former Yugoslavia because it came into existence before Rwanda. But for reasons of being able to expand on certain aspects, we are able to start with the Rwanda Tribunal. Anyhow, right now we are proceeding on to the Yugoslavia, the former Yugoslavia Tribunal. Okay, let's just give a little introduction to the ICTY, which is International Criminal Tribunal for former Yugoslavia. The International Tribunal for the Criminal Tribunal was established for purposes of prosecution of persons responsible for serious violations of international humanitarian law that were perpetrated within the territory of the former Yugoslavia during the period 1991, since the period 1991. You'll recall that in the ICTR case, that is in the instance of the International Criminal Tribunal for Rwanda, the matters that were being dealt with under that jurisdiction were those that occurred during the period between 1st January and 31st December of the year 1994. Okay, so you can see there's a gap. There was literally a gap between when these events occurred, atrocities that were committed that are being referred to as international violations of international humanitarian law. And that was a commonplace term that was used during the time prior to the coming into effect of the ICC, as we shall see later. Okay, so when there was atrocity, there was real ethnic cleansing. You'll all remember the story of Bosnia, Herzegovina, and all those other struggles and wars that took place that cost a lot of lives. The international community was arisen and got concerned to be able to handle the situation. So this body, which is the ICTY, was established by the United Nations. The United Nations organs, that is the United Nations Security Council, had to pass a resolution to establish it, just as we saw in retrospect in the case of the ICTR, the Rwandan Tribunal. So unlike the ICC that we examined some time back in other lectures, as you will refer to, you will recall that the ICC was established by way of the Rome Statute. That's by way of a treaty of the state parties. So it is the parties that came and established after a protracted conference, established the existence of the International Criminal Court. So unlike the International Criminal Court, the International Criminal Tribunal for Rwanda and for the former Yugoslavia were a creature of a resolution by the United Nations Security Council, and as a consequence of other deliberations before the other United Nations organs. Okay, so we did indicate that these tribunals were confined to particular events. And in the case of the ICTY, which we'll be referring to International Criminal Tribunal for former Yugoslavia, it was because of the wars that occurred in the Yugoslavia and the atrocities, the war crimes, and all kinds of crimes that shocked the concerns of humanity that were perpetrated by certain powerful individuals, politicians, military leaders within those regions. Okay, so the tribunal, therefore, by virtue of that, was ad hoc in the sense that it would have to exist for as long as the kind of responsibility or mandate that was entrusted to it was to be disposed of. All right, so let's get back to how the tribunal was established. By virtue of Resolution 827 of the United Nations Security Council, which was passed on the May 25th, 1993, the court was formally established. It was created. It came into existence. The United Nations Security Council passed this resolution, which of course set in motion, authorized the formation of the ICTY. And the jurisdiction relating to the ICTY had to be stipulated. Just like we saw in the ICTR, usually there's a statute that of that particular ad hoc that sets out the jurisdiction and other operations. The core jurisdiction of this particular institution was to be able to, it had 4 clusters of crimes that it had to deal with that were perpetrated, allegedly perpetrated within the territory of the former Yugoslavia since 1991. So it had to deal with grave breaches of the Geneva Conventions. You'll recall that the Rome Statute was not yet in existence at that time. And that's the one cluster of crimes. The other cluster was crimes against humanity. So this term existed even prior to the coming up of the Rome Statute. And we had also genocide being dealt with. And last but not last, not really less important in the list, it is violations relating to customs and laws of war. Those gross violations of those customs and laws. So there was need to attend to this. Like we saw in the ICTR, the ICTY had the jurisdiction in terms of meting out punishment or sentence. It had only a maximum of life sentence. That's all it could do. There's no death penalty as it is in other states. So that is very critical. All between these all tribunals and international criminal institutions, the maximum sentence that would be meted out, like at the ICC, is life imprisonment in very extreme situations. Okay, so apart from the sentence, it's also clear, as we shall see later, that when a custodial sentence has been handed over as a result of the consequence, then there are a number of states that will be able to take up the responsibility to provide custody requirements within standards. Okay, the tribunal was established and it was located at The Hague in the Netherlands in Europe, just where we have the International Criminal Court seat currently. So a number of persons were inducted by virtue of this ICTY tribunal, and quite a number of them, of course, were subjected to the process. But first, let's look at something that is very important. We've looked at the creation. We might want to look at how still aspects of the creation. It wasn't just a one-stop activity that was carried out by the United Nations Security Council, but it entailed a lot of processes. So initially, this court idea was proposed. As you'll see that before the tribunals featured, came into prominence or in view in arena of international criminal justice, we had other tribunals, we had other establishments like the international military, the military tribunals, where we said last time that it was the victors' justice, sort of. Whoever won the war would turn against those who perpetrated crimes in the other camp. That did not seem to well represent the concept of international fairness or fairness in international criminal justice. Okay, we need also to point out that it's not only one resolution that was passed. A number of other resolutions were passed in connection to be able to consolidate the operations of these tribunals, including the ICTY. Let's now look at how this was implemented. So in 1993, the ICT established its own mechanism, the organs, the means of operations. And as I said, a number of states volunteered. 17 states came up and signed an agreement that they would be able to take responsibility in terms of custodial sentences handed down to whoever would have gone through the tribunal. Okay, so we now have a tribunal as a judicial organ at the international criminal justice plane. So between the period of its formation, 1993 to 94, it set on establishing the infrastructure and the necessary organs that would be able to see it fully functional. It set up the framework, institutional and legal framework for it to be able to operate. And they came up, the judges and the institution itself came up with rules of evidence and procedure that would be able to govern its mode of operations. That was quite an achievement in terms of what the ICTY did, because it was the first time that it was being able to codify and come up with coherent procedural normative rules to govern the operations of an international institution, albeit the one that is targeted, ad hoc, targeted at a particular territory and a particular set of individuals. Okay, so we can see that it was quite a mammoth challenge, and it was not just a matter of the internal operations of the institution itself, but also the infrastructure, the building in which it was to be established. We know that during that particular time, the teething challenges entailed even space. And so the ICTY court shared building with Aegis Asian, which is an entity that was an insurance building, actually. That is where they started off from, so they even shared, and that is how challenging the start was in terms of operations of the ICTY. Okay, now we know that the ICTY is established in The Hague. There was also the issue of detention facilities, as we already indicated. Those were also established at The Hague in the Netherlands. And it had to get competent staff, the judicial officers and other support staff to be able to carry out the functions and to enable it to operate. All right, investigations were to begin in earnest, as that was to be able to provide grounds for the ICTY to be able to initiate the process of prosecution and meting out justice in respect of those offenses. Let's look at how the operations occurred. How did the ICTY, let's look at operational matters, administrative matters that went on. Okay, we have in history, this was a record that the first indictment of a suspect before the ICTY was carried out in 1994. That particular suspect was arraigned before court, and the suspect was a prominent figure. That was very critical. It sent a message to all the other perpetrators and those who were still within the theater of operations that even the Bosnian sub commander, Dragan Nikolin, could be brought before a tribunal to face justice, to take responsibility for their acts. So indictments were issued during that particular time that's around the ensuing year, 1995, which entailed 21 personalities who had to be arraigned before court. These ones were particularly the Bosnian Serbs who had perpetrated extremely egregious offenses against the Bosnian Muslim minority. It was an aspect of the Croatian, the Muslims and the Croatian civilians actually as well. It was an aspect of ethnic cleansing. It was cleansing based not just on ethnic considerations, but also on issues of faith. So it was a very serious set of systematic extinction of people because of what they believed in. And the international community had therefore to come into effect with all due haste to be able to contain and arrest the impunity that was carried out. So we are seeing that the ICTY set operations as a first institution to be able to send signals to the world that impunity would no longer be tolerated. So it was a movement that we are seeing a movement now from impunity itself to people taking responsibility for their actions that they carried out. Okay, so that is a very critical point to mention. We have, as we said, we indicated that indeed there were a number of crimes that were placed. There are clusters. So the indictments, of course, would embrace a number of charges. We indicated in retrospect there are 4 clusters largely. Some of them are now replicated within the Rome Statute, which is the ICC that we saw a couple of weeks back in the other lectures. We can see that genocide had its origin, it was already in existence. It was being dealt with under the ICTY. Crimes against humanity, that was also being dealt with. And war crimes, which was looked at a bit differently under the ICTY as laws and customs, violation of laws and customs of war. These are people who went against the normal convention of war and probably carried out torture and unjustified mutilation and persecution of individuals with whom they were engaged in combat. It was a situation of combat. That was not handled with respect to customs and laws that ordinarily governed the conduct of war between states. So these individuals who violated this with impunity had to be brought before the ICTY to take responsibility for their acts that were carried out in flagrant disregard of the conventions that were in place. Of course, it was sending a signal to be able to deter. It had the effect of deterring and offering justice also. It was not just deterrence for those potential offenders, but also to be able to offer justice, some kind of remedy for those that went through conditions that were set by these individuals. Okay, so arrest warrants are to be issued to be able to bring the suspects before court. All these systems were already getting into place. And we can see that really the ICTY experienced teething challenges of its own unique nature at that formative stage of its operations. And operations were confronted with a lot of challenges, both logistically and both normative. And so the court had started generating jurisprudence, a system of belief, a system of procedure, a system of conduct proceedings before court. And that was a commendation. It is credit which must be given to the existence of the ICTY, the International Criminal Tribunal for the former Yugoslavia. Okay, but let me just quickly summarize those accomplishments, the achievements that I've just stated. I said that notwithstanding the challenges, the teething challenges, the teething impediments, the bottlenecks, those factors that were inimical towards the attainment of justice or the operations or administrative issues by the ICTY, they made commendable achievement that must be noted in the circumstances. So we can say that in international law, there was quite an achievement. There was quite a step that arose as a result of the ICTY. What is this? Because we know the Nuremberg trial, the Nuremberg court, the military court, if compared by that, there are quite a number of concepts or normative issues that were never settled through those tribunals, military tribunals. So we have the ICTY that sits and tries to generate jurisprudence and provides guidelines and beefs up, reinforces, buttresses the concepts within the realm of international criminal law. So there was development that was attained in certain respects in terms of international law as a whole, not just international criminal law. Okay, that was very important. And as I indicated, when sending signal of deterrence to those potential offenders, it was in effect sending a message that the rule of law must be secured. There must be rule of law in traumatized communities, and that those who are still perpetrating violations with impunity of rule of law principles would be subjected to the same process of justice. So this was an attempt to be able to reinforce the principles of rule of law internationally and between states, between nations, and assuring the world that no impunity shall be tolerated, that flagrant violations of established principles and norms shall not go unpunished in the circumstances. Okay, this court as well achieved, because remember I did indicate at the start that the judges were able to sit and come up with rules of procedure and principles of how to operate the court. This was very critical because it helped in the process of being able to gather evidence. It was establishing, a system that was now coherent in being able to acquire cogent evidence towards with probative value and establish probative value evidence to support the cases in order to apply the law to the facts that have been gathered through those evidence. All right, and so we'd see, as we said, the jurisprudence was very critical. The jurisprudence was, as reflected in the rulings and judgments, would be able to survive for a while, and it's important. That's owed to the existence and the process of the ICTY. Okay, I did indicate, and I just need to reemphasize that the existence of the court also brought now into fore the issue of accountability, of taking responsibility. There was no more impunity that would be tolerated, and that every individual implicated in acts that were heinous, that were egregious, that went against the fundamental principles that for good order, that perpetrated crimes that cause atrocities in traumatized communities would not go unpunished. So we could see a shift from people acting flagrantly with impunity to now people being held accountable, being held responsible, taking responsibility for their actions. So any action that you take, there are consequences that attend to such actions. Those are very critical points that we need to note. And of course, we see that the overall net effect of all this process of the ICTY was to be able to deliver justice to people of all kinds, the victims, all the parties, the victims, the survivors of those crimes, and witnesses as well. Basically, justice was being dispensed and being made available to persons who had been traumatized, who had suffered in the hands of the perpetrators. And so we saw that this also acted as an encouragement for interested individuals to come forward and be able to present evidence, because there was already a system to see that they're protected. So this is actually something that was very, very critical that we needed to mention about the ICT. Why? Okay, having said all that, it is critical to get into, I'll be dealing with how the ICTY was structured. We saw in retrospect, as we were dealing with the International Criminal Court, as we dealt with as well the ICTR, that there were structures, there were organs that were established to be able to see the court operate. In the case of the ICTY, we had principally 3 organs. One of them was the chambers. Under the chambers, we had judges and those that were supporting the operations of the judges. Chambers was, in terms, we had the appellate structure. The hierarchy was such that there was the appeals chamber, and they had 3 trial chambers. Trial chamber 1, trial chamber 2, trial chamber 3. Of course, the appeals chamber, which is the appellate hierarchy of the court, was to attend to any appeals that emanated from the lower chamber. But it is critical to note at this point that this appeals chamber was so unique that it did actually even handle matters later, ultimately, that emanated from the other tribunal. But for now, let's focus on the structure itself as it appeared within the ICTY. So the chambers was composed of the judges. There was a president of the tribunal himself, who also at the same time doubled up as a judge, the presiding judge of the appeals chamber. Just like we saw in the ICC, the president of the ICC also convenes and sits at the appellate chamber of the International Criminal Court. So is the case with the ICTY. Okay, so towards the end of these operations, the judges, there are 7 permanent judges towards the end of the operation. We see that actually the tribunal was ad hoc and had to come to an end at some point or the other. However, there was a large number of judges who had been appointed to attend to our tribunal matters. A lot of them, close to 86 judges. And 52 of them were from member states. And it was critical that member states participate. But then we also had, as we saw in the other course, ad litem judges. An ad hoc judge was part of the whole structure. Okay. So this slight number became a concern. At some point, we would see that, well, the number was large to be able to expedite the process of dispensation of justice, but all these had cost implications, and that will be addressed shortly, and see how the the Security Council responded to these situations. Okay, I won't go into details about all that because I'm just having a run-up of the structure of all these might form future individual elaborate, detailed, comprehensive lectures. So we're just having a rundown of the whole process. Okay, I may not go into the names of the judges, but the thing is we had judges who had to sit on the trial on the appellate judges. The other structure, that's the structure number 1, organ number 1. The other organ was the registry, as we stated. The registry, as we saw in the case of the ICC, had the responsibility to provide operational and administrative matters to support the other organs. This is the same thing. The registry was headed by the registrar and was responsible for dealing with issues, operational issues, as well as administrative issues, such as, transport, providing accommodation, dealing with witnesses, and also advising the public, providing information to the public. It also got concerned largely with maintenance of records of the court, preservation of those records, and a number of other administrative issues. The staff, generally human resource issues, procurement, logistics. And also it oversaw, as we said, there was the detention unit that was established in The Hague, in the Netherlands. The registrar was responsible for overseeing that one and ensure that those inductees were available. It also ensured that, for instance, those who are not able, who are impecunious, are not able for any reason to support themselves in terms of financing legal representation, legal aid services were available for them, are free of charge. Okay, since we have mentioned the detention facilities and units, as we stated earlier in other lectures, this was basically a 10-meter squared room, but the standards were quite comfortable to meet the international minimum standards of detention. What was underscored here was the fact that the persons who had been indicted before the court were, for the time being, were hitherto considered presumed innocent and not guilty until the court establishes otherwise. So there was need to provide them with all the basic amenities, television, they would be able to prepare their own meals, and in a way, they lived in luxury. Okay, that is as far as that. Then we have the third large organ of the ICTY, and that is the prosecutor, the office of the prosecutor. That's a very instrumental office in terms of the operations of the tribunal. As we saw, the purpose of the office of prosecutor is to carry out investigations and bring the evidence and proceed with the prosecution based on the evidence they have. The entire process of investigating, gathering evidence that in their view would have probative value. Preliminary processes, interviewing witnesses, all this was part of the responsibility of the office of the prosecutor of the ICTY. And as we said, this prosecutor was a very important person, very pivotal. And the ICTY prosecutor was appointed by the United Nations Security Council and had to be nominated by the Secretary General to be able to be part of that process. I won't go into the names for now, but at some point we'll be able to handle that more exhaustively. So that deals with the issue of the structure. Quickly, I'll look at the other issue. As we said, there are a lot of trials that have taken place, and there are a number of acquittals. I won't go into the statistics for these purposes because this is just an outline. But the underlying factor here is that a lot of indictees were persons who emerged from different ranks of the military, most senior, most responsible persons, politicians who had control, and it was clear that some politicians would be able to shield those suspected of crime, and nothing, sham crime or anything, nothing would proceed. Okay, so we had this going on. We had people like Ratko Mladic, Radovan Karadzic. All these are familiar names that we came across, we not ordinarily come across. Okay, as we said, the first request was to refer in the Tradic case, that was 1994. And we also have a case of a number of presidents, like the President of the Republic of Serbia, Govan Hadzik. That was the last fugitive of the tribunal. Okay, I want to touch on something here, which at this point I feel is critical. But just before I get into it, I want to look at the issue of closure. Let's discuss what negative points have been advanced about this court. Much as it did very well in terms of dispensation of justice, generating jurisprudence, there was a lot of criticism that was being advanced against the existence of the ICTY. One, that actually as these indictments were going on, there was simultaneously war going on in the former Yugoslavia. So was there any impunity being arrested, or it was just a process that had no seen destination? And so a lot of matters piled before the judges and the whole structure of the court, which was almost being brought down, and the system got overwhelmed. And so we see that the existence of war at the same time, the process going on was quite a hindrance. It seemed not to have been logically, well, nothing should have stopped the indictments proceeding, but you look at the thing that we have war still going on and people are being arrested and indicted. It would appear like the court was being overwhelmed massively. Okay, also there was the other argument that these processes, instead of introducing healing among the people, actually exacerbated the process of division and hatred among the different groups. It made the situation worse. So that is also very clear. We can see the consequences. It had unintended consequences in that respect. Okay. We also have the issue of costs that were coming up before the court. These have been challenges that run through most of the international criminal institutions. That to sustain this cost becomes a bit of a cumbersome job and becomes a challenge. You can see there were a number of judges, a lot of them, and the court was getting overwhelmed. And so there was concern. There were also arguments that the court was not actually delivering, leaving out some individuals, and this was of concern. There's so much mix-up, but this is expected of as teething issues that were raised, that were coming up in the process of a new tribunal. The other thing was there are those who argued that some of the sentences and the punishment meted were lenient vis-a-vis the crimes that these people committed. Those are expected, and those kind of arguments would still run through. Okay, others even questioned the authority, the legal basis of the establishment of such a tribunal. Those kind of debates were sustained and went on. But in effect, what we're saying is that apart from that, the court did tremendous job, and notwithstanding those criticisms, we've had a lot of literature that, when read, indicate that the ICTY did a great job in terms of justice, being pioneering aspects of a codification and systematic way of evolving jurisprudence. Okay, at this point, we'll recall that I said this was an ad hoc tribunal, in the sense that it had to come to an end at some point. And as we saw in the ICTY, there was need to bring all these institutions to an end because they were ad hoc, and especially in the light of the ICC coming up, there was need to wind up the operations of the tribunal and focus But as we can see, it was not possible. Some of these matters still hung on. So there had to be closure in terms of, there had to be an end to the operations of the tribunal. There had to be winding up. And so we could see that the winding up would not be very decisive without the rest of the matters which were still being under trial, those who are pending appeal. The United Nations Security Council, as we saw last time, passed other resolutions in the year 2003, seeking that the ICTY and the ICTR be wound up. They should be able to fold their activities by 2010. But as we saw in the case of the ICTR, this was not practicable. There was so much that was outstanding that they kept on postponing. There was still a postponement until we saw that the proper winding up in most of these cases went on at around 2014. But it is critical to note that during this resolution, the time this resolution was passed, that by 2010 there should be actually another resolution, Resolution 1966, was passed by the United Nations Security Council, establishing the International Residual Mechanism for Criminal Tribunals. The IRMCT, as we mentioned, was established purposely to take over the residue of the cases that were still hanging before the two tribunals, the Rwanda Tribunal and the former Yugoslavia Tribunal. The trials that had not been wound up had to be pushed on. Those that had no appeal, the appeals that were made before the establishment were to be wound up, but those appeals that were filed after the establishment of the criminal or of the International Residual Mechanism for Criminal Tribunals had to be handled by that particular tribunal. So it is important. We'll see that the tribunal, the International Residual Mechanism for Criminal Tribunals was established in the year 2010. That was in December, towards the end of the year, at the end of the year actually. And that there was Resolution 1503 in 2003 and 1534 in 2004 that sought to have completion of all the cases before those sister tribunals. Okay, so we see residual mandate that is now conferred to the IRMCT, the International Residual Mechanism for the criminal tribunals. So there was another resolution that was passed. That was Resolution 1966. That resolution ensured that in all finality by the end of 2014, as I said, 2014, all the matters that were being handled by the sister tribunals had to close down. There was the issue of costs, and all responsibilities and mandates and all the transactions that were going on must be able to get transferred to the IRMCT. So that was under what we call the completion strategy. The completion strategy was what was evolved by the Council to ensure that there was completion of the ad hoc mandate of the ICTY and the ICTR. Okay, so we see that all the appeals had been handled by the ICTY by the year 2015, with the exception of that of Radovan Karadzic, whose trial, of course, was expected to end around 2014. We have Mladic and Hadvik, who are still at large at that particular time, and those are other issues to be handled. Okay, so we see that the IRMCT, the International Residual Mechanism for the Criminal Tribunal, had branches within itself. It had the branch that was handling the residue matters from the ICTR, and another branch that was dealing with the residual matters from the ICTY. It began to function in earnest in the year 2013. That was July 1st, 2013. Of course, there are transitional issues that had to be handled to enable the transfer, the completion strategy to evolve through. But all in all, the matters ultimately were handed over to the IRMCT to ensure that all outstanding issues, residual matters, were brought to completion. As we said, the mechanism was for dealing with residual issues. It was a tribunal that was handling residual matters. Okay, but remember, I did indicate that if an appeal had been lodged prior to coming into effect of the IRMCT, if it had been lodged before any of those tribunals, those appeals will not be part of the issues to be transferred. It was only procedural that the appeals had to be finalized by the institution. So all other appeals that were finally lodged against all actions or decisions of the two sister tribunals were ultimately taken over by the international residual mechanism of the criminal of the court, the residual mechanism for the criminal tribunals. Okay, so that is as far as we go, and we know that Madavik was convicted in the year 2017 ultimately, of course, after all this transitional process was sorted out. And the final case on appeal proceeded where there were 6 suspects or 6 convicts who were appealing their sentences were finally upheld. Those sentences were upheld on the 29th of November 2017. Okay, on that note, I just wish to quickly recap that it brings us to the end of our lecture. The ICTY was one of the sister institutions, ad hoc institution whose mandate was established by the Security Council, and the mandate was ad hoc. It had to expire at a given time. We also saw, in retrospect, that the tribunal was established to be able to carry out prosecutions of individuals responsible for serious violations of international humanitarian law, and that this was concerning all matters that happened in former Yugoslavia since 1991. We also saw that the major crimes were established, were under 4 clusters. And the 4 clusters involved the violations of the laws and customs of war, genocide, crimes against humanity, and the grave, we're talking about grave, not just minor breaches, grave breaches of the Geneva Conventions. All those form part of the jurisdiction of the ICTY. And we did mention that the maximum sentence that could have been meted out by the International Criminal Tribunal for Yugoslavia, just as the ICC and ICTR, was life sentence. There's no death penalty that was being meted out by this institution. We also saw that subsequently, the court was established and judges were appointed, a lot of judges, over 86 of them, and that was meant initially to expedite the process of justice, but it turned out to be that the costs were mounting, and issues that were raised already about how the court was being lenient and was not issuing stern sentences. But those were advanced as a way you'd expect in any situation. Okay, we saw that almost over 160 individuals were indicted before this tribunal. And we also examined the fact that the resolution that brought into existence the court, the ICTY itself, was resolution, United Nations Security Council Resolution 808, and that was of 2nd February 1993. It effectively established the ICTY. And I just mentioned passing that a common phraseology at that time was violations of international humanitarian law. Okay, upon the operational issues and the implementation involved even states, about 17 states who had to get into some kind of agreement or treaty to be able to accept detainees or people sentenced under this system, dispensation, within their state territories to serve the sentences that were issued. The other clear important issue that we mentioned was that the first indictment was issued against, there were quite a number of senior people, but what was issued against Nikolic. And we said most of these prosecutions involved high personalities, people of great responsibilities, senior military individuals, politicians who are hitherto reluctant to be able to prosecute or they're trying to shield their crimes or carry out some sham proceedings in their countries to protect them. We also indicated that there are a lot of achievements that resulted from the ICTY. It was able to reinforce the principles of the rule of law, and that it introduced universal accepted standards in terms of the war crimes. So we also saw that justice, the concept of justice for victims and for the participation of the victims, their voice to be heard was a very critical development from this process. And we also indicated that there was now more about movement away from flagrant impunity by individuals to taking responsibility for the consequences of their actions. So that there was more of holding people accountable for the egregious atrocities committed in traumatized communities. And we saw that the court streamlined its process, started working out procedural rules and other operational rules for court procedure and court proceedings that turned out to be critical in terms of gathering evidence for their, and also, coherently arriving at decisions. Okay, we saw that under the structure of the court, the organs were three. One, we had the chambers, and the chambers was divided into four. I would say they're divided into two broadly. We had the trial chamber. There was not pre-trial chambers. We have it in the ICC, but we had trial chamber 1, trial chamber 2, trial chamber 3, and matters handled by these trial chambers were subject to appeal to the appellate chamber, which was presided over by the president of the tribunal, similar to the situation we had in the ICC. So the president of the tribunal would preside over the appeals chamber with the other judges. We also say there are quite a number of judges, almost 86 permanent judges, and we had also ad litem judges as well as ad hoc judge to be able to deal with the issues of dispensation of justice in these circumstances. And finally, I just want to mention also that since the ICTY had a limited mandate in terms of being an ad hoc tribunal, it had to come to an end at some particular point to ensure its mandate had to expire. And this mandate, as we said, kept on being extended. Initially, it was decided, the United Nations resolution, like the ICTR as well, they had decided that both sister tribunals would be able to wind up by the year 2010. But that was not possible because it was overwhelmed. Notwithstanding that, by 2010, the ICTY, the International Residual Mechanism for Criminal Tribunal, was established as a body, as an entity, as a tribunal to be able to deal with matters of residue that were not, that overflow overflowing the mandate of the two sister tribunals. So we say that finally there was extension granted to the sister tribunals to wind up their operations, and these extensions extended on until finally by 2014 they completely closed down the two tribunals, and matters were transferred. All the other matters were transferred to the IRMCT, except, as I said, there was the appeal that was outstanding. All the issues that were outstanding in the case of Radova, and some of these matters were ultimately, of course, wound up by the year, like NADIC, the year 2017. But in effect, the IRMCT started operating immediately upon the institution of its own mechanism to be able to deal with matters. Okay, within the IRMCT, we had the branch that was dealing with the residual issues that were transferred, and then from the ICTY, another branch with the ICTR. But that will form the basis of our next discussion. That brings us to the end of this lecture, and I want to thank you very much for your time, for being able to follow this lecture despite the hard lockdown, COVID-19 times, wherever, in any part of the world that you are in. Our next lecture will now focus on the international residual mechanism for the criminal tribunals, how it operates, what is the status. I'll be able to deal with that. But for now, we have had just a rundown of the two sister tribunals that were ad hoc and whose mandate had expired. Thank you very much. I also wish to indicate that you get onto my LinkedIn profile. You'll be able to see we have indicated we're going to have a live panel session only a few hours from now, probably in the next, at the time of this lecture, we say at the next probably 30 hours, we'll be launching a live expert panel discussion. It will be a discourse on the International Criminal Court, and in that International Criminal Court issue, we'll be looking at prospects and challenges that are confronting the court. We have lined up a team of experts, real experts in international criminal law, who should be able to benefit your viewers, and we welcome you to participate in the proceedings. Your presence will be highly valued. The experts can be seen on those lines, but just a hint, it includes a renowned attorney, trial attorney who has appeared. I'm mentioning that because I've just dealt with the ICTY. He'll be able to shed more light into the ICTY. He's been able to appear before the ICTY and has done commendable investigations. He's the co-chair of the American Bar Association. That is Attorney Arthur Toldy. We also have Attorney Marotta, who is in charge of the International Criminal Court for against child kidnapping. These are very seasoned lawyers, and you need to listen to what their expertise brings in on Friday. That would be 3 o'clock South African Standard Time. That would be Friday would be 2 o'clock London time, British summer time. New York all the time is provided there. You'll also have occasion to listen to other professors of law who have specialized in international crime. Professor Enzo, who is based in South America, who has done commendable job in international criminal law. He's done vast research and been able to supervise a number of prominent lawyers. You need to listen to what he has to tell you about international criminal law. He's also the director of the International Criminal Law Journal. And so that is a very important resource for this particular panel, just like all the other resource persons. Also in the list, we have Professor Dr. Alessandro. She is also a very experienced academic and scholar. She is a professor of international law. She's widely read and she's widely researched, and it would be helpful and nice to hear her give us hints on, give you listeners highlight issues that revolve around the ICC. She's based in Italy. That is very critical. Marotta is based both in Europe and in the United States of America. In our list too, we have Professor Shripathi. This is based in India. He's a well-renowned, presenter of matters of international law, and he'll be there also to provide sufficient support. I'll be there as well, Professor Dr. Advocate Milton. I hope I've not left out any person in that group. We are a team of 5, including myself, will be, yeah. So we have Professor Enzo, we have Professor Dr. Alessandro, we have Professor Shripati, we have Attorney Traldi, and we have Attorney Marotta. Thank you very much for listening to me, and that brings us to the end of this lecture. And wherever you are in this world, I wish you all the best. Thank you very much.